Welcome to Cut to the Chase, where we talk about compelling legal, regulatory, and public interest information and news. Your host is Greg Goldfarb, an attorney, entrepreneur, investor, and activist.
All right, folks, it's time for our favorite podcast, Cut to the Chase. I'm bringing on two lawyers from Miami, Jed Kurzban and Taylor Hill. How are you doing today?
Very well, thank you, Greg.
Doing great.
I saw that they co-authored a very interesting article called Neither Goose Nor Gander, Why Tort Reform Fails, to talk about tort reform in the state of Florida, which I would imagine is occurring elsewhere. Actually, I just got off the phone with one of my buddies in Texas, and he said that what we're doing they did years ago, and they're now digging even deeper into their tort reform. So, I'd like to give both of you an opportunity to discuss what tort reform is, what's happened in Florida, and has it succeeded. So I open the floor up to both of you.
Sure. Well, thank you. I'm very happy and honored to be on this with you, Greg. I think that these are great forums to help both give information and educate those that don't know, as well as to sort of spread the word on problems we have and how to make them better. And that's really a big part of why both Taylor and I do these articles. So a little brief about me. I'm a trial attorney. My first trial was 2 months after I took the bar, and I've been trying cases ever since. I do personal injury, but I specialize in medical malpractice. And what got me interested in this is I do medical malpractice cases all over the country. I'm asked to help either try cases first chair around the country or give advice, jury trial advice. And I saw how each state was so different in their approach to personal injury, including medical malpractice. Medical malpractice is the most restricted form of personal injury because the insurance companies are just so powerful and wealthy, and they're able to lobby for a lot of rules that protect insurance companies and hurt people. And in truth, doctors are simply caught in the wash. They're not protected by tort reform, but they're not educated enough to know why. And individuals, you, me, our neighbors, our friends, our family, are victims of tort reform because what tort reform does nationwide is it, one, limits access to the courts. Two, it restricts your ability to even bring a suit if you're allowed access. And then three, it limits your recovery, even if the limitations far surpass the needs of what it is. The needs surpass the limitations of what's provided. And so in three ways, tort reform fails. I think Taylor could tell you she's a young attorney. She's been with me a few years. She's been involved in a lot of these cases. And this became a real passion project for her once she saw what was really happening in Florida and around the country. Taylor?
Absolutely. And, when you're in law school, especially when I was fortunate enough to clerk for Jed, they teach you a lot about reading the law, right? But they don't teach you about the intent behind it, who's lobbying to get it passed. And so a lot of the rose-tinted glasses I had kind of in law school, learning about what it was like to be a trial attorney, none of these issues were being discussed along the way. And so when you get into actual practice, coming from the clerk to the attorney side of things, it's really fascinating to see how these laws actually affect how we practice as trial attorneys in the state of Florida. And I think if a lot of younger law students were aware of what the trial attorneys who have been kind of battling it out in Florida for the past 30 so years knew, I think their eyes would be open to just how important preserving our civil justice system is, and just how much we need to be talking about the ongoing attack that these lobbying efforts kind of force upon us as civil trial attorneys and upon our clients who, at the end of the day, it's our job to provide the best case possible. And these laws, they quite frankly just get in the way of that.
I can't begin to tell you how many times people have called me up with medical malpractice claims that sounded good, sounded good in the sense that, it sounded like the doctor messed up, the hospital messed up. And, there was no way I was going to take the case. And I knew no one else would because of all these limitations that you're touching base on. But I want to set the stage a little bit because some people have heard about the tort reform recently. The tort reform that you guys are talking about in your article has been going on for years, and that's the medical malpractice side. Recently in the state of Florida, we did insurance claims in general and basic personal injury cases were also restricted in terms of when you could file and all these other limitations that really are helping no one except for the people that have done the wrong and caused the harm. So let's wind the clock back. When did this apparent crisis in Florida first get, noticed? And who was behind it? Was it the medical community? Was it the insurance community? Was it what was behind it? And when did it start?
So tort reform really sort of began in the 70s, but it was more of an attempt to help the civil justice system back then find fairness, efficiency, predictability. And that is really what you want a civil tort system to be, right? In any case you have, can you be efficient? Is it going to be fair? Is it going to be predictable to some degree? And that's what you're looking for. The problem is it became bastardized in the 90s. Without getting political on the podcast, Republicans tend to be pro-tort reform. Some Democrats do, some don't, but as a whole, most of the tort reform that you see that's really bad is generally a pro-Republican platform. And what they want to do is limit accountability and limit recovery. And the question you have to ask yourself is, why would anyone want to limit accountability or recovery? In a hurricane, you want recovery. In a product liability case, you want accountability so they could fix the product. Why is it in medical malpractice they want to remove accountability? It's an interesting question that you need to break down. So who's behind it? The insurance company. The insurance companies are behind this. They have untold, literally billions of dollars that they've put towards lobbying to prevent accountability, to prevent access. How have they done that? They've done that in a lot of nefarious ways. Here in Florida, currently, we have a particularly weak governor. And the governor is very happy to accept what lobbyists pay for access to get to him, to talk to him about limiting this recovery and this accessibility and accountability. They do that by saying, how could a patient that got hurt, and he's hurt, how could he sue and get tens of millions of dollars? We need to stop that because it hurts everybody when that happens. Okay, sure, that's true unless the person needs tens of millions of dollars because you paralyzed him from the neck down, and it costs a little over $17,000 a day to provide all the care and treatment needed because they need to be fed, bathed, washed, physical therapy, speech therapy, occupational therapy. The house needs to be redone. Ramps have to be put in. Faucets have to be lowered. It is a tremendous expenditure to provide treatment for someone that's been life-altering hurt. So the question is not, why does he deserve the money? Because he's been destroyed. It's, how did we get to this point? How did the medicine become so bad that you misdiagnosed the cancer, or you operated on the wrong organ, or you misdiagnosed? In my case, I do a lot of failure to diagnose cancer treatment or kidney treatment, which can come from various forms: natural kidney disease, diabetic kidney disease, cancer in the kidneys. These things are misdiagnosed. Why are they so often misdiagnosed? So break the problem down, right? They're misdiagnosed because no doctor could see 30 people a day and make a good diagnosis. Cannot. You could treat 30 colds a day, but if someone has a rare disease, it takes more than the 8 minutes if you're lucky enough to have 8 minutes with a doctor. I'm not telling you or your subscribers or anyone that follows you anything they don't know. Go to your doctor. How much time do you spend with your doctor? Greg, how much time do you spend with your doctor?
I spend probably more time than he would like to, more than 30 minutes, but I choose a doctor who specifically basically promotes himself as somebody that will give you time.
So he's
That's
probably a
like-
concierge doctor if you got that kind of time.
Yeah.
Certainly not some HMO doctor like most people have. So you can't see 30 people and make a hard diagnosis. So now you're seeing too many people. Why are you seeing 30 people a day? It used to not be like that when you and I were kids. Why is it like that now? The insurance company says you want to get paid. This is the number of people you need to see. So that forces you to see too many people. That forces you to miss a diagnosis. That causes a medical malpractice claim. And the answer of our governor or tort reform governors is it's the patient's fault. Let's limit their recovery and limit their access.
Okay. Let me ask you that. Let me ask Taylor this. All right. I'm going to play devil's advocate, or I'm not. You know what? I retract that statement. What about all these frivolous lawsuits? They've been going on for years. All these people, they just file whatever, the judge doesn't care, the jury doesn't care. They just award hundreds of millions of dollars. How do we deal with that? I mean, isn't that a big problem?
Actually, a great question and something that initial researchers into tort reform looked at. They said, hey, we're worried about the premiums rising. We're worried about all the costs and expenditures of lawsuits. So obviously, tort reform has got to be the answer, right? We got to limit these quote unquote frivolous lawsuits. But if you look a bit further at even the initial, what was called a task force that the Florida legislature assembled to address tort reform, they found no evidence of frivolous lawsuits being filed. What they found were large payouts of worthy lawsuits that had astronomical damages, kind of what Jed was alluring to. So it's not necessarily that these frivolous medical malpractice lawsuits are being filed. And to a lot of attorneys' credit, it's actually quite impossible to get a frivolous lawsuit through this free suit process that we have now because of tort reform, through this expenditure to an expert testimony, kind of another level of tort reform we have. And on top of that, through the actual motions of a medical malpractice lawsuit. And so, not to diminish some of the fears that a lot of people have in this space about talking about tort reform, but when you talk about medical malpractice specifically, the idea that there are hundreds of frivolous lawsuits in every circuit in Florida backlogging our civil justice system, well, there aren't really any numbers supporting that myth. And if they do exist, I have yet in any of my research to come across numbers substantiating them. Instead, what we have is a realization that, quite frankly, medical malpractice and medical error is expensive. That's just the reality of both medical care in this country today and what happens when you need to actually get access to healthcare to support yourself following medical error. And so it's not so much a matter of there are frivolous lawsuits everywhere backing up our civil justice system. What's really happening is as medical care and medical error becomes more expensive, the amount of damages being requested in these cases, like anything else that's rising because of inflation, gets higher. And that's really what insurance companies are lobbying against, is having to pay for the error that results and the damages that come from medical malpractice.
All right. I want to follow.
I'll give you a basic example, Greg, that might help. In Florida, you have to file a medical malpractice lawsuit, an affidavit from a physician that says I reviewed all the records and my opinions, A, B, C, D, and E, are stated because I think there's a breach of the standard of care. That's a good plan, right? And these doctors, they don't review hundreds of pages of medical records for free. They don't file affidavits for you for free. So these cases cost $5,000, $10,000 just to start pre-suit. What lawyer is going to spend $10,000 on a frivolous case? Because that's a basic minimum to start. Now, I'll take the other side for you. The pro-tort reform people have decided that it's too easy to spend $10,000 on a doctor. And so they made new laws. For instance, they tried to say only Florida doctors can testify in Florida. Florida doctors won't testify against their buddy they play golf with. So now you go get a doctor from Harvard, head of Harvard, top orthopedist in the country. Can you tell me if malpractice occurred? Yes. I'll pay you to give me the affidavit, review the records, tell me what you think. Okay. Now they're saying he's not a Florida doctor, he can't testify. So now they said, if you go to a board that we, the insurance company, create, we'll determine if we think this head of Harvard orthopedics is qualified to talk about orthopedics in Florida. It does not sound like access to the courts. It's quite the opposite. It's not a frivolous lawsuit that they're fighting. It's every lawsuit. Frivolous lawsuits in medical malpractice simply aren't there. There are no numbers to support it.
Okay, us lawyers, we use the word pre-suit, and it's like, part of our DNA. But just for the audience out there, Taylor, and you brought it up first. What is pre-suit, and what is this? How does this affidavit flow from this pre-suit requirement?
Oh, pre-suit is essentially medical malpractice's lawless land. It is at minimum, 90-day phase in which us as the plaintiff's attorney has to put the defendant, physician, nurse, hospital on notice. On paper, right, the statute says essentially, hey, the point of pre-suit is to get rid of all of this stuff tort reform fears. The high verdicts, the frivolous lawsuits backing up the court systems, and the lack of accountability for physicians acting in error. So the point of pre-suit is essentially to mutually investigate, come to an agreement, and resolve before we need to get to court. That's all fine and dandy in writing. What actually, for the majority of cases, ends up happening is it's a 90-day investigation period that often gets extended by defendants, if not once, twice, up to 3 times. The number of extensions doesn't need to be reached a limit because there is no court oversight in pre-suit. So there's no one to monitor and enforce fair play in the pre-suit process. They are allowed to take written or oral testimony from our client. They're allowed access to my client's entire medical chart. They are allowed to essentially riddle us with discovery. We are allowed to serve discovery in turn. Basically, an entire lawsuit takes place during this 90-day pre-suit period, and none of it ends up being admissible if a lawsuit is actually filed at the end of pre-suit. So if we're talking about, quote unquote, the intents of tort reform, saving resources, quickly resolving issues, admitting fault when fault exists, pre-suit was created to achieve all these goals, but has since been kind of implemented as a way to further delay, further shirk responsibility, and further limit what plaintiffs can recover by essentially kind of exhausting them, making them not enjoy the process, making them fearful of what's going to be an even more hard-hitting lawsuit after the fact. And so pre-suit is something that was pitched as something that we really all on both sides could have agreed with. But as we've seen since it's been kind of implemented over the past couple decades, it's not monitored, it's not enforced, and there's no record evidence that comes out of it. So if anyone lies under oath in pre-suit, that omission or that deliberate lie is never actually used as an impeachment material when a real lawsuit is filed.
All right, so you're talking about monitoring and all that. Have they kept statistics that show, let's just say, how many claims have resolved during the pre-suit process? I mean, has there been any level of success?
So the success has come in liability payouts, but the courts do not make a distinction in the Office of Insurance Regulation, who keeps all of the liability payouts reported annually and actually creates a great annual report, does not make a distinction between when a lawsuit is done in pre-suit and when it is done during a regular lawsuit. The question becomes whether attorney's fees have been expended defending the suit. So that's kind of the only way to tell how far along a claim goes, is how much a defense expenditure of defending the suit is taken out of the insurance money. Other than that, we have no real good reporting information. as to when these claims are being resolved, whether it be pre-suit or by the courts.
All right, so Jed, patient comes into my office, they had a gangrene left arm, needed to be amputated. Doctor amputates the right arm, clear malpractice. You, as anybody off the street, could figure out that there was a mistake. You find a doctor who's willing in Florida to review the records, that they don't even really need all right, but they review the records and they sign an affidavit saying there's malpractice. You send that report out, that notice to the wrongdoer. Do they even have to respond? Or could this just be a complete waste of time?
It is a complete waste of time. I want to expand on one word Taylor said, fair play. If I do not comply with pre-suit as a plaintiff, my case is thrown out and dismissed. I have to do everything they ask. If the defendants do not comply with pre-suit, they're not allowed to dismiss my case for not complying with pre-suit. That is the only punishment to defendants not complying. There is no teeth behind pre-suit for the defendants. All of the punishment comes to the plaintiff. So they have no need to respond. Sometimes they don't. Sometimes they respond and say, we don't care. They are allowed to force me to arbitration in pre-suit, where we arbitrate to resolve the case or the claim. To do that, they need to admit liability, which they don't like to do, so they rarely arbitrate, even though arbitration severely limits the recovery. So it's a very pro-defendant process where they don't have to comply. If they're brave enough to say, my mistake, I'm sorry, they severely limit what I can recover. So pre-suit is really a terrible one-sided position. It's part of the problem with the whole idea of tort reform. I don't want to be too long-winded about it, but the idea of tort reform really is supposed to be, let's try to reserve resources and efficiently and effectively resolve this obvious case you brought up. Gangrene in one arm, you cut off the wrong arm. What's to fight about? Figure out how much money it takes to help that person. All the medical bills in the past, all the medical bills in the future. Whatever it costs to get the arm back, an orthotic arm, whatever it costs to help the family. Maybe, they're right-handed and that's their dominant hand. So they need help doing things now. They can't sign checks. They used to love to play golf. Now they can't play golf. Maybe they have to buy a left-handed set of golf clubs. There are things that are in place that normal, average, regular people who live amongst each other could say, let's do this, it's the right thing to do. But that's not tort reform. Tort reform is do everything defendants say or we throw your case out. Defendants, you don't have to do anything. You don't have to agree to anything, help anything. You could lie under oath, cheat and steal. There's nothing anyone could do about it.
All right, before we move on past pre-suit, one last question to the both of you. In your experience, and from what you've heard from your other colleagues, has there ever been a successful resolution of a claim through the pre-suit process that you've experienced or heard about?
Both. Personally, we've resolved several in pre-suit, successfully. The whole idea of the arbitration is because it limits recovery and fees, it's sort of like a hard threat. Like, we'll settle with you now, but these limitations exist, so you have to take a little less. All right, it happens. And sometimes a little less is okay if it still supplies what the family needs to recover. So yes, there are successful recoveries in pre-suit, but very, very rarely. Any plaintiff lawyer will tell you for every 30 cases they file, maybe one settles in pre-suit.
And has that been your experience too, Taylor?
So
Absolutely. In fact, one of the first cases we took on when I passed the bar was a case that resolved in pre-suit. And I remember Jed turning to me and saying, I don't want to sound dramatic, but this has never happened before, right? And it was quite frankly, a case that I would have been shocked if they didn't offer to arbitrate, because we essentially had documentation of the physician lying about a procedure he did and lying about a piece of tissue that he removed from our client, point blank in a lie. And those are the kind of cases that if pre-suit arbitration is offered, that's most likely what they're going to resolve, because defendants are essentially trying to keep all of that bad act out of the public record, out of the public eye. And so that's where the pre-suit arbitration, I think, really comes in handy. It's for the ones that would really, really, really rub a jury the wrong way. They want to limit that liability, and they want to limit that visceral reaction to a physician lying about what they did to a patient.
All right, so I'm practicing law for 30 years. Throughout, I would say, the first 10 years of my practice, I would consistently hear that the malpractice insurance premiums are skyrocketing in Florida, that doctors are leaving the state of Florida because they can't afford to, or they're not getting insured, and that the quality of medical care is suffering because doctors are practicing defensively. In other words, they either are over ordering tests, they won't perform the complicated procedure, or they're just so nervous they don't know what to do. So to me, that all sounds believable. It sounds like a crisis, and it sounds like reform should have taken place. So am I wrong? Talk to me.
You're not wrong. We have some of the highest premiums in the country, and they're rising despite decades of tort reform, countless restrictions on our rights, countless restrictions on access to court. Our physicians are still paying the highest premiums in the country. So it begs the question, if in 1981, 82, you promised if we passed this law, your premium would go down. Then in 1987, you said, all right, that one law wasn't enough. We need an additional law. This will be the law that brings your premium down. Fast forward to 1995. No. We need 3 laws now. Fast forward to 2004. All right, we need a complete overhaul of our tort reform system. 2024, we had yet another overhaul of our tort reform system, each time with the promise that this will be the reform that brings your premium down. And each time, the premiums increased. We have had no significant decrease in premiums despite over 40 years worth of tort reform. And that's not just a Florida problem. That is across the nation as well.
Does the
Let me ask you
legislature?
this, Greg.
Yeah.
If I told you that Florida doctors are not insured because they don't need to be insured. So, they made rules that your mechanic is required to carry insurance because they scratched a senator's Mercedes once, and he demanded every single body shop carry insurance, but not doctors. They don't need insurance. So doctors are bare. So only the really, really successful doctors get insurance, and they pay really, really high premiums. Why is tort reform not working? Perhaps the problem is not lawsuits. Perhaps the problem is if every doctor was insured, good and bad, and therefore every doctor shared the risk of every other doctor in Florida, but now you have millions of doctors getting insurance over the years, would that bring the premiums down? In the rest of the nation, the answer is yes. When doctors have insurance, premiums come down. When doctors don't have insurance, premiums go up, smaller pool. And you could look this up. National average, Taylor found, what is it, Taylor? 70% of lawsuits, medical malpractice lawsuits, are against the same 3% of providers.
Wow, that's crazy.
So why are you protecting those bad providers, hurting everybody? The problem is not the plaintiffs. The problem is transparency. Make medicine like buying a car now. When you were younger, you bought a car. No one knew what the car is really worth, what it cost. But now there's transparency when you buy cars. You know what it costs for the manufacturer. You know what it was worth. There's Carfax and a million different variety of situations that explain the breakdown of car buying. Car buying is not like it used to be because there's transparency. Why is medicine still shrouded in hiding information, covering up, not allowing any transparency? The problem is not the plaintiffs. The problem is trying to protect an insurance industry that is making profits of 400%. Think about what business makes 400% profit? Not my business, not my uncle's hardware store, right? Not my cousin's food truck. None of them make 400% profit. Why do insurance companies make that kind of profit? Because they're protected by a government that's failing the people.
All right, let me go back to your point, Taylor, that there have been a few times over the past 40 years where they continue, the legislature, Florida legislature continues to try to protect the rising insurance premiums. Have they acknowledged that despite their prior efforts, the premiums are continuing to go up? And do they have an explanation, or do they not even acknowledge it?
You know, it's interesting. It's not even that they have connected the dots, right? They're saying every single time a premium rises, we need more tort reform. We need more tort reform. No one is ever doing the work to look back and think if any of the tort reform we're implementing does what we say it's supposed to do. And that's the main issue. And I think a lot of that issue comes from a misunderstanding of how tort reform works, right? Because the whole premise of tort reform was that we were going to have lesser insurance premiums. And by having lesser insurance premiums, we would have better physicians and better medicine in Florida. Instead, we have higher, more prohibitive insurance premiums, some physicians even going there, to Jed's point. And we don't have the accountability of an admission of fault because, as we previously talked about, doctors don't want to admit when something went wrong because they can't afford another rise in their premium. So it creates this vicious cycle of rising premium and decreasing quality of healthcare. And because of that, we're seeing more expensive medical error, more frequent medical error, and more widespread medical error across specialties, especially when it comes to now the conglomeration of healthcare by large corporations kind of buying out our mom and pop shops, right? You're getting a CHI, a Baptist, a Lynn Health, you know, different kind of systems are now kind of automating a lot of what used to be an individualized patient on patient and physician experience. And so I think, to kind of get back to your question, the issue is tort reform is causing these increased premiums because they're not getting to the root of the cause of increased insurance premiums, which is bad healthcare that's getting worse.
So I don't want to overgeneralize, but it sounds like Wall Street has taken over healthcare to some degree.
To a
It
great
has.
degree.
And
And
is trying to make money.
that's their job, right? It's like saying a company's bad. No company's bad. Companies want to make profits. But there are rules that can be placed to limit bad actions. And those rules simply are being misapplied. They're restricting plaintiffs when in truth they need to restrict how this medicine gets applied in this large conglomerate form of medicine we currently see. A lot of people don't know in Florida, if you are unmarried and have no minor children and a victim of malpractice, you can't sue. It's literally known in Tallahassee as a free kill.
Explain that. Explain. So they passed, was it a law that said that these people can't sue?
It's a law. It's part of tort reform. If you're unmarried and have no minor children, a 52-year-old divorcee, a 62-year-old widow, and you have no minor children anymore, and they cut the wrong arm off, you can't sue. It's a free kill. If they kill you, if they just cut the arm off, tough luck. You still can't sue.
Yeah, but that's for those that die.
It's for any malpractice that occurs to adults unmarried with no young children,
where the resulting injury is death.
Doesn't have to be death. They've cut the wrong arm off. You still can't sue.
Oh, you still can't sue. Wow. All right. So we've also got in the and I want to talk about the one time that it sounds like the Florida Supreme Court had an opportunity to dig into whether the crisis really existed. And that is, I guess, back in the 80s or 90s, Florida passed legislation to cap non-economic damages. When did that happen, and what are non-economic damages And what was that all about? And then we'll lead into the Supreme Court decision, the state of McCall decision that kind of looked into what was really going on.
Sure. So going back to that task force we talked about earlier, one of the findings of this legislative task force was that the quote unquote #1 driver of nuclear verdicts and of the increase in premiums was juries being sympathetic and awarding non-economic damages. That is, the pain and suffering of being a fully visual person who suddenly goes blind because of medical error, or the loss of a child due to medical error, right? The things that can't be quantified by bills or by a vocational expert, these kind of human damages that happen to us. And so the task force said, hey, because these are unpredictable and because juries are easily misled, let's call it, we need to cap these damages so that we can have more fair play at $500,000. The reality of the situation is,
Hold on, just think about that, Greg. If you, I don't know, you're from Florida, you love to fish, and they cause nerve damage in your arms and you can never fish again, ever. Or play golf, and you can never play golf again. Does that have a value to someone? If that was their life's passion, if that's, I want to retire and play golf, and I hurt you and you can't play golf again, is there a value? Tort reform says no. We'll give you back your medical bills. If you've lost any earnings, we'll give you those. But your life's passion, your dreams, those have no value in Florida. That's outrageous.
Yeah, well, I mean, if you're paralyzed, you can't pick up your grandchildren, you can't drive and watch them play ball, you can't play golf, you can't do anything that, I mean, enjoying the enjoyment of life is, what
Life.
else is there?
That's
Right?
what life is.
All
To
right.
take away your enjoyment of life is to take away your life.
So we're going to cap that at $500,000. That's going to solve the problem. So talk to me, what happened to that? And what did the court do in the state of McCall versus United States?
They simply said there's no such thing as this insurance crisis. It's made up and not true. Well, they said it more politically correct in that it might one time have been true, but they don't think it's true any longer. And these limitations seem unconstitutional.
and essentially what they did was look back at the people who initially were pro tort reform. The head of the Office of Insurance Regulation even testified in front of our very state Senate saying, actually, I'm not sure that any cap on non-economic damages would do anything for what we want to do, which is decrease insurance premiums. Even in the 80s, at the inception of this purported crisis, the people that were advocating for it were doubtful as to the cause in the first place. And the Supreme Court in 2014 said, hey, that was over 30 years ago and they were doubtful. We've got 30 years of reform later, and my doubts are not being reassured by anything. In fact, we are not finding any connection or any relief from this tort reform. So why do we still have it? And that's kind of where we're at now, right? We're 40 years down the road. We've had countless tort reform. We've had countless restrictions on our rights. What is the benefit we've gotten in return if premiums have increased, healthcare has decreased, and us as civilians have gotten no accountability for the past 40 years of the stripping of our rights?
In your article, you mentioned I think the phrase was the underwriting cycle of insurance being the actual situation, I guess, for the spikes in the premiums. Explain what you mean by that.
So when you have an insurance market, there are natural times where you're going to have a sort of reserve, right? Insurance companies tuck away money when they assess liabilities and think to themselves, okay, I have X many claims outstanding. They're this far along. Here's how much money I need to put in my back pocket to get rid of these claims. That's also interplaying with the natural cycles of our economy: inflation, deflation, access to goods, people being employed, people being unemployed. Our insurance industry is never constant. It fluctuates with the value of the money insurance companies have in reserve, the amount of premiums that are being paid out, the amount of premiums and subscribers an insurance company has. All of this interplays on a yearly basis to kind of fluctuate our market. And instead of saying, hey, insurance is inherently an unpredictable market given all of the economic factors that go in, and the fact that we have insurance for the very first place is to pay out when these mistakes happen, that whole natural cycle has been omitted from the tort reform conversation. And instead of explaining it to civilians and saying, hey, your premiums increase and decrease relative to all of these economic factors, they pointed the finger at lawsuits and said, ignore the economy, focus on the plaintiffs.
So the way it works, Greg, is I'm going to sue for a big claim. They didn't diagnose kidney disease, and they know that they could lose $3 million in this case. So they take their $3 million and they put it in what they call reserve. And they know they're going to fight me for the next 2 years. And if they lose, they're going to pay me the $3 million. And if they win, they don't. But they know for 2 years, their $3 million has been gaining interest. So really, they're going to pay me $3 million and they're going to make $600,000 in interest on the money they already allotted to me. So when the economy's good, they make their 600 grand and no one complains. When the economy's bad and they don't make that kind of interest, or they lose $3.5 million to me and they've only put $3 million in reserve and only got 200,000 in interest because the economy's bad, they say, oh, that's an unpredictable result. They got $3.5 million. We're going to go bankrupt now. Has nothing to do with my lawsuit. My lawsuit's literally irrelevant to the fact when the economy is good, their reserves are up. And when the economy is bad, their reserves are down. But it's easy to blame lawsuits.
All right, let's talk about solutions. We've touched on a little bit of it. Is there any state that's doing it right? Or are there multiple states that are doing it right?
Yeah, multiple. I mean, so the article is filled with examples, including the Michigan approach, right? Which has a lot of transparency and accountability. And if you let people know, hey, report the problems to us so we can fix those problems, and therefore those problems don't get repeated, lawsuits go down. It's really that simple.
It sounds pretty logical to me.
Pretty logical and simple. Instead, in states like Florida, Texas, it's hide the problem, repeat the problem, blame the plaintiffs.
Yeah. Plaintiffs, consumers, we're all basically, I'm sorry to use this
Your
word.
fault. But we're going to hide the problem so no one knows it and we never fix it.
Okay, last topic. I've read, I couldn't give you, a citation here, but I've read that there are statistics about like hospital error, medical errors in hospitals, medical errors outside hospital. Are there statistics being kept? Is it a problem? Who's keeping these statistics? Are they reliable, or are they just some plaintiffs firm hiring their own people to come up with the result they want to see?
There's
Absolutely
both state
not.
and federal statistics. Medical errors are the third leading cause of death in America. Think about that.
And hospitals are required to actually report either near miss incidents or accidental prescription incidents, anything that there is a medical error. Hospitals do keep running lists of these incidents. The question is, do we consumers know about them, benefit from them, and get better healthcare after learning from these mistakes? And that's the disconnect we have because of tort reform. Rather than saying this near miss happened because of XYZ, here's how we get a better chain of command, or this prescription shouldn't have been filled this way because it counteracts with this client's other drug. So we need to be better about our record keeping across systems, right? All of these realistic day-to-day issues in medical care, they're not being addressed. And instead, what's happening is deny, defend, keep trucking, and hopefully in another 10 years, the plaintiffs will give up because we'll finally have enough tort reform to have free reign. And that's what we're advocating against here is no one thinks doctors and hospitals are deliberately hurting people. We're just growing bigger and more complex as technology grows and gets crazier. And as a result, we're seeing increased prescription error, increased charting error, and increased error because unfortunately our doctors and nurses are understaffed, overworked, and getting exhausted. No one's intentionally hurting patients, but what's happening is we're having a system that's failing them. And rather than learning from these mistakes and implementing better chain of command or better policies to counteract our failings, we're denying they're happening in the first place.
So you're left with really two options.
Yes.
Transparency and accountability. Let's do better. Or deny, defend, delay. And that's really, you got two camps. And that's really what tort reform is. Either you're pro tort reform, defend deny, delay, or you say, let's have transparency and accountability. Let's make the system better. We have the ability to improve it. Why are we not improving it?
Tort reform. It sounds good. Hey, listen, I heard tort reform. Let's do it. That's great messaging. You know, I mean, the problem is the messaging gets out there. People hear tort reform, frivolous lawsuits. Oh my God, we have to do something. Crisis. Insurance premiums are going through the roof. We got to, you know, these plaintiffs' lawyers are killing us all. All right, folks. I mean, you got to get past the messaging. You got to start to dig deep, because when the medical mistake happens to you or your family member or your friend, and they are going around and they cannot find one attorney that wants to take the case, you have to ask yourself why that is the situation. All right. And you know, lawyers, young lawyers that are getting into the space, medical malpractice and all that, and maybe you're interested in lobbying and doing right, read this article. It's in the September-October issue of Florida Bar Journal. Neither goose nor gander, why tort reform fails all. They're doing more of it in different genres, and I think we're going to get the same results. And the people that suffer are us, the consumers. All right.
Yes.
So I thank you both for coming on to the program. Shout out to your uncle Ira, who's also a legend in the immigration space. Just had to get that in there. And Taylor, thanks for coming on. There were two others that authored this publication, this article, Lauren Gallagher and Camila Torres Jaramillo. I didn't want to forget them as well. And I don't know, is there anything that we missed? Anything you want to end the show on?
No, I think you did a great job. Thank you. I think when people put people first, good things happen.
All right.
And when profits are put first, bad things happen.
You got it.
That's really all tort reform is. Profits over people, when in fact, as I tell juries every time I'm in front of them, it should be people over profits.
That's right. All right. So folks, that'll do it for this episode of Cut to the Chase. If you have any questions, comments, if you want to subscribe, helps my program, rate, review. I'm going to put the article link in the show notes, and Jed and Taylor's info as well. If you have a med mal, they also do tort law and personal injury law as well. So thank you for coming on, and that'll do it for this episode.
Thank you,
Thank
Greg.
you.
That's all for this episode of Cut to the Chase. But before you go, will you open up your podcast app and give us a 5-star review? You can also leave a comment about what you liked most or other topics you'd like us to cover. And please be sure to subscribe so you don't miss any upcoming shows. Thanks, everybody. Be safe out there.